Good evening, friends, and welcome to another edition of Crime Time with DutyRon and Ed Wallace. We are retired New York City police detectives and 9/11 World Trade Center first responders. If you like all things true crime related from the police detective's perspective, you're in the right place. Hit that subscribe button, hit that notification bell, so you get all things DutyRon and this guy. He's here, back on U.S. soil, Ed Wallace, when we go live or upload another video. Hey, tonight, friends, we want to talk to you about something that we've been wanting to talk to you for a long time. The Karen Reed trial, the crime scene and the evidence collection failures. And trust me, there's a lot of failures. Ed's going to have a lot to say tonight. But, you know, we wanted to wait until the defense and the state rested. And today the Commonwealth rested, and so did the defense. And we really have everything that we need to look at evidence-wise from both sides. And in my opinion, and I'm going to go out on a limb here, I'm going to say that the Commonwealth, led by Mr. Lally, has not proven beyond a reasonable doubt that Karen Reed did, in fact, murder police officer John Okeefe. And the reason I feel like that is because I watched the same thing that you guys all watched. And I know, Ed, you were in Morocco and you were watching it too. I just wanted to go to you quickly. First, welcome home. Everybody loves that you're back. It's good to have you back. I know that it took a little while for you to come on with me, but you had a lot to catch up with. But how was your trip and how's everything going, Ed?
The trip went well. It was a great job working with the forensic professionals on the gendarmerie and the DGSN police in Morocco, and working with the embassy and the law enforcement technical working group there. And it went well. I'm very happy with the results. And I'm good. It's good to be home. And I had a couple of nice days up in Maine, visiting Portland and Bar Harbor. And I ate my share of lobster with my family, and it was a great time.
Excellent. Excellent. Well, now you're back home. We're jumping into this thing, and it was at your request. I was kind of surprised because I didn't know if you were going to be ready to talk about this, because we had no idea that this was this was going to be the result of the Commonwealth. This is all that they had. I was still waiting for more. I don't know about you. I was waiting for more, and they didn't deliver. A lot of people in the chat are going nuts. And here, I wanted to highlight just this one little comment. And they were talking about Jenny made a comment. She said she really was impressed with the expert from the ARCC. Was that? Did I get that?
That's the accident reconstruction.
Yeah, yeah. Your thoughts on him today? Did you see him testify?
The doctor, yes, very well.
Yeah, yeah. He reminded me of you a little bit, Ed. And
well, he was a true forensic practitioner and professional, unlike his counterpart from, was it the state police, accident reconstruction, quote unquote, expert?
Trooper Paul. Trooper Paul actually made me cringe, and I think everybody else cringe, when he was cross-examined and he had no idea about simple things that somebody in his position should know about, Ed. And I know you said that you watched it as well. Really.
It was definitely cringeworthy. Now, folks, you know, I've preached this numerous times. I'm one of those people who believe that forensic practitioners, and it is a practice, just like a doctor or lawyer, engineer, architect, nurse, whatever the case may be, all these licensed professionals, that we should be licensed to practice crime scene investigations, to do shooting reconstruction, bloodstain pattern analysis, to do accident reconstruction, okay? And, you know, this is, you know, what I saw here, there were many cringeworthy aspects of the forensics that this drove me nuts, okay? Lack of proper photography, proper protocols and procedures, oh, we didn't have a way to do this. Well, there are protocols and standards for these things. And if you're going to be in this business, then you need to know what they are, and you need to be trained on them, and you need to practice. So whoever trained these people to process crime scenes, whoever trained them, failed these people. And if they don't have the skill sets or the equipment or the training to do it properly, then they should have reached out to an organization that does. Okay? Because listen, we have the power of life and death in our hand. We could take away somebody's freedom. We could take away somebody's life in the death penalty cases with the work that we do. In addition, if we don't do our work properly as forensic practitioners, we're victimizing the victim again, as I feel is the case here. We have a victim who is dead. The forensic work, being kind, was shoddy and failed that victim.
Yeah.
Okay. And now, where do we go? Where do we go to help this victim and their family?
Yeah, police officer John Okeefe is dead. And at this point, as far as I'm concerned, we don't know who killed him or how it happened exactly. We don't know if he was beat up inside that house, taken into the basement, bit by the dog. There's so many unanswered questions. And who I feel really sad for is the Okeefe family. When I look at these people, I say to myself, they deserve better. And you see, here's his dad in the background and his mom with her head down. And you look at Karen Reed, who's accused of murder in the second degree. This trial has been just an emotional roller coaster, Ed. And I want to put us back on the screen because the defense team, Alan Jackson, David Yannetti, Miss Little, have represented their client in such a professional way, and they've gone after the Commonwealth with vim and vigor. And, you know, this is what you'd want if you stood accused of something like this. And Karen Reed has stated her innocence throughout this whole trial. I was hoping, and Ed, this is just an open conversation, and for all of our live chatters, I was hoping that the Commonwealth would have given us more. And the disappointment when you have a Boston police officer dead on another police officer's front lawn, another Boston police officer's front lawn, I'm talking about the Alberts, you would expect that they would throw the kitchen sink at this thing. The Canton police were obviously not equipped to process a crime scene. We heard from Lieutenant Gallagher, who stated he never processed a crime scene in the snow. What is that?
We live in the Northeast. Are you kidding? They live in New England. You'd never processed a crime scene in the snow, then you shouldn't be doing it now.
Mm-hmm.
If you don't have the skill sets, you don't have the training, the equipment, and you don't know the correct protocols, then call somebody that does. There's no shame in that. There is no shame in that.
And the crazy part is that they did, and they did it a little too late, but they did. And look at what they got. They got the Massachusetts State Police, and they screwed the thing up. I mean, their CERT team came in there with the shovels and the sifting through the snow out in the front. They found the shoe. Listen, we're getting ahead of ourselves. I want to pull the chat here quick. I have a very short kind of overview of from day 1 to day 29. It will take us about 16 minutes to play it, 16 or 17 minutes, but it's short snippets from each day. And we could go through this in less than 20 minutes, I think. By a show of hands in the chat, who wants to see day 1 to day 29, which ended today? Put a 1 in the chat if you're interested in that. Put a 2 if you'd rather us just tackle the forensics, because we are going to tackle the forensics. We're not going to stop and break down each day. But day 5 and the day Trooper Paul, I believe, was 25 and 26. Those are days that are most concerning to us. And Ed, you're a seasoned, you've processed arguably over 2,500 crime scenes in your career. Have you ever heard of something like this, Ed?
No, I'm disgusted by the whole thing. And here's another thing I teach my students all the time. Stay the hell off social media, okay? Dump all the Facebook accounts and all the social media accounts. And don't you understand that everything you do in this day and age, it becomes evidence. You're texting about an active case. You're texting about a defendant, okay? Mm-hmm. And you're making these unprofessional remarks to your colleagues as if the defense doesn't have a right to this information. What century are you living in? Okay. Right. There was so much unprofessionalism here. It was disgusting.
Yeah, and they never went inside the house at the location of this incident, right? They never went into Fairview. They never went into 34 Fairview. I was shocked by that. I was like, wait a minute. You find a dead police officer and you're not going into the Albert's home? Is it because he was a cop and the Lieutenant Lank, who interviewed him before Lieutenant Gallagher even knew it by his own admission in court? That's his lifelong friend from childhood. They're childhood friends. I mean, that in itself, I would never be charged with investigating another officer's death if I was lifelong friends with the occupant of the residence where this alleged murder took place, right? But they did. They let that lieutenant go in and talk to him, but they didn't search the home. They didn't go in there, and they didn't do any kind of crime scene processing inside that home. They just concentrated on the exterior. Crazy. All right. Everybody said they want to see this day 1 to day 29. We're going to do it quick. We're going to get through it. So this way everyone has an idea of how this thing unfolded. It's troubling to say the least, but let's let it rip. These are only a couple of minute clips for each one of these. This is day 1. We're going to start with day 1 right here.
Karen Reed entered the courthouse and listened as the prosecutor described how investigators believe she killed her boyfriend, Boston police officer John Okeefe.
The defendant, Karen Reed, is guilty of murder in the second degree, striking the victim, Mr. Okeefe, with her car.
WCVB animation shows how Reed had driven Okeefe in her Lexus SUV to a house in Canton for an after-hours party, but then left without him. The next morning, Okeefe's body was found lying in a snowbank near a fire hydrant in the front corner of the yard. The prosecutor said Reed slammed her SUV into reverse and hit Okeefe going more than 24 miles an hour.
Knocking him back onto the ground, striking his head on the ground, causing the bleeding in his brain, swelling, and then leaving him there for several hours in a blizzard.
But Reed's defense attorney said Okeefe went inside the house, where he said he was killed during a fight and a dog attack.
Her car never struck John Okeefe. She did not cause his death, and that means that somebody else did.
Reed's defense attorney did not name that somebody else, but said the owner of the house is being protected because, like Okeefe, he is a Boston police officer.
He had markings on his right arm. I didn't notice anything on the other side.
On the witness stand, his brother Paul described seeing John O'Keefe's body in the hospital and remember seeing Reed there as well.
Again, we saw Karen Reed being restrained by hospital employees, screaming the same things. Is he alive? Is he alive? Is he alive?
Testimony has concluded for today, and a short time ago we saw the jury, 17 people altogether, 10 women and 7 men, leaving this back door of the courthouse. They got on a specially chartered bus with heavy police escort and left for the day.
So there it is, day 1, and I'm going to move quickly right on to day 2. And this is the defense team outside of the courthouse, walking into the courthouse. Day 2, Karen Reed trial.
Their case against Karen Reed, prosecutors now have 2 witnesses who say they heard Reed confess at the scene, where they found her boyfriend, John Okeefe, lying in a snowbank.
As I was ventilating, I was able to ask, did anybody see anything? What happened? And there was one individual that replied several times, I hit him.
EMT Timothy Nuttall did not specifically name Reed, but remembers it was a woman with blood on her face. Canton police officer Steve Seraph says he heard Reed say, "This is all my fault."
You changed your story, didn't you?
No.
But under cross-examination by the defense, Seraph admitted he didn't include Reed's alleged confession in his initial reports.
You think that was a pretty important omission on your part?
It was an oversight.
Another police officer does not remember Reed confessing, and none of the first responders remember seeing any pieces of Reed's taillight, which prosecutors say shattered when she backed into Okeefe with her SUV.
Did you see 45 pieces of bright red, black, and clear plastic pieces scattered all over the scene?
I did not.
Prosecutors suggest that's because it was snowing heavily at the time. The defense says the pieces were planted at the scene later by dirty investigators.
They seem to find it hours and hours later when there was much, much, much more snow on the ground, right? So that dog doesn't hunt.
A Canton firefighter took the stand late today, but did not finish his testimony.
So there's day 2, Ed. We're going to go through this quickly because I want to get to day 5. When we get to day 5, we're going to talk just a little bit, obviously a lot about this, because that's what this live stream is going to be about, this evidence collection. But again, here with day 2, they're talking about 46 pieces of a taillight. Nobody noticed it. Snowstorm and so forth.
Remember Licard's exchange principle, right? And so if that was in fact the case, you would think that when you do your crime scene walkthrough and then your preliminary search, that these are things that you would have found. Now, when you're searching a crime scene in the snow, in a blizzard, and I've done it, okay, the first things you're going to do is non-destructive methods, okay? What are you looking for here? So we suspect vehicle accident, or do we suspect an assault, and then followed by an animal attack, okay? What are the theories that are going on here? Okay, and once you establish those theories, then your hypothesis, not a theory. So you establish a hypothesis, and then you start searching, keeping those hypotheses in the back of your mind, looking for evidence. And none of that was done here. None of the proper photographs were done. None of the securing of the crime scene was done correctly. I mean, we're going to go on. We'll talk more about it.
Yeah, a lot of things were not done, and for those reasons alone, the jury could find just reasonable suspicion that they have not proven beyond a reasonable doubt, the Commonwealth, just based on this shoddy evidence collection here. And there's so much doubt that the defense brought up, so much doubt. So yeah. What do you got there, Ed?
No, we just don't wait for the evidence to reveal itself. We go out and we find it. We look for it. We search for it. Okay. We don't wait for the snow to melt. We don't use leaf blowers, and we don't use red Solo cups and used shopping bags.
Yeah, shopping bags. Crazy. Here's day 3, folks, and we're going to get through this quick.
We have heard from 7 police officers, paramedics, and firefighters who were there that morning when John Okeefe's body was found. And so far, 4 of the 7 have testified that they heard his girlfriend, Karen Reed, make an on-scene confession. Police dash camera video shows EMTs arriving with a stretcher, then loading John Okeefe onto that stretcher and performing CPR as they roll him towards an ambulance.
So CPR was initiated by me.
Lead paramedic Anthony Flamati says he was about 2 feet away from Karen Reed when he remembers her saying,
I hit him. Oh my God, I hit him.
Under cross-examination from defense attorney Alan Jackson, paramedic Flamati admitted he never put that in his report. And 2 other paramedics say they never heard a confession from Reed. But paramedic Katie McLaughlin, who was told at the scene specifically to ask Reed about what happened, says she heard it several times.
She repeated, I hit him. And there was a police officer who was in that vicinity kind of with us who replied, you what? She repeated it one more time.
So if you could, listen as best you can.
Reed's attorneys repeatedly played the audio from the dash camera to try to prove Reed never said I hit him, but in the courtroom, it sounded like this. Mainly wind and muffled voices.
Are you sure the jurors are hearing what you're hearing?
Well, they're going to in the deliberation room. No, I'm not sure they're hearing what I'm hearing right now, but they will in the deliberation room.
Now, the judge has imposed a 200-foot buffer zone around the courthouse in which demonstrations are banned during this trial.
Remember that, Ed, the 200-foot buffer zone and how outraged everybody was about that? And, there was a lot of restrictions put on this trial for people who were supporting Karen Reed, and they made them all stay back. And they still, obviously, right throughout this whole trial did this. But day 3 was, again, just a little bit more of us hearing from the paramedics. And when we listened to testimony, we were hearing that everybody seemed to be intertwined with the Alberts. Everybody seemed to be intertwined with this location where police officer John Okeefe lost his life, where he was murdered. And
the street was like Copville.
yeah, it was insane. But the lack of details, the lack of people documenting things, this was like a nightmare when it comes to forensics 101. Nobody was documenting anything. And look, not even a sketch was drawn of this crime scene. They didn't even have a location exactly sketched out where John O'Keefe's body was. We had to rely on a picture of snow that was where his body laid. That's what we saw in the courtroom. It's just insane.
Well, to be fair with that part of it, life safety comes first. So if EMTs and once they start working on him, if they felt they could, treat him and save his life, that has to come before the evidence. Okay, I get that. Okay, but then as soon as the body was removed, one of the first officers then should have marked out that location where the body was. Right, the crime scene tape should have already been up. Okay, and keeping the neighbors out of the yard and so forth.
Yeah, and I think there was, from what I remember, there was not many people out because it was a snowstorm. So none of the neighbors, there was no like community unrest, and there was not a lot of people out. As a matter of fact, according to the Alberts, they didn't even wake up. The dog Chloe didn't even bark, and they didn't know that there was a crime scene with a fellow Boston police officer dead on their front lawn. Nobody knew. It was a shock.
You mean the dog that got rehomed?
The dog that conveniently got rehomed, and it was said that the dog was not available for the defense to go up there and take a look at. Crazy 101, but let's go into day 4 here, because I want to get to day 5, because that's when it gets crazy.
2 911 calls that morning. The first saying that Karen Reed was freaking out because her boyfriend, John Okeefe, had not come home that night. And then the second saying that Reed and 2 other women had just found O'Keefe's body lying in a snowbank. Now in court, O'Keefe's family, they wiped away tears as that second 911 call was played for the jury. Karen Reed, she stared straight ahead. The woman on the phone in the call, she asked the police to send an ambulance as soon as possible. And the dispatcher asked if the man in the snow is still breathing.
Breathing sound. It doesn't feel like she's breathing. Okay, do they know there's CPR? Do they want to test you? Yes, you got to do CPR. No, I guess he's gone. Oh, okay. They don't feel comfortable doing so? No, I think he's passed away.
Taking a look at
Officers described how they borrowed red.
Okay, so this is day 5. I skipped day 4, but this is day 5. This is how the blood in the snow was collected in, looks like 6 solo cups in a ShopRite bag.
Now, when we collect blood, we have to collect blood for probative value. Okay, is there any doubt to whose blood this is? Or why was this blood being collected, and why in this manner? Okay, first of all, anybody worth his salt in forensics knows that if it's frozen, you keep it frozen. You don't go and get your neighbor there to give you some red Solo cups that he has laying around this house from some unknown party, and you have no idea about the cleanliness, the sterility of these cups, and you don't borrow or use ShopRite. It was a Stop and Shop bag. Right. You don't borrow, use paper Stop and Shop. And if it's frozen, you have to keep it frozen. Okay. At this point, you cannot let it thaw out with the ice. Okay. And then it's going to become diluted. So what you do is you scoop it up into a sterile urine cup, or a sample cup as we call them, and you put it on ice in a cooler and you keep it frozen. You let the lab take care of it from that point. You rush it to the lab. Okay. I don't understand any of this.
Let me ask you, Ed, about that concept right there. This lieutenant, right, Lieutenant Gallagher, and we're going to look at his testimony, and Lieutenant Lank, who's friends with Chris Albert. There was plenty of snow opposite 34 Fairview. There was plenty of snow everywhere around outside of that crime scene, right? They talked about the massive amount of snow. These guys were all, I want to say Canton is a drinking town. People are out drinking. They love to drink. You mean to tell me nobody had a cooler They couldn't have went back to that lieutenant's house and said, hey, you got a cooler in your garage? Let's pack this with ice, the snow, and put these cups into the cooler or whatever, right? Or and say, right. So Ed, they were thinking out of the box, but they didn't apply.
There was no reason to think out of the box. There's protocols and procedures for this.
Right.
Okay. I mean, you telling me you don't have sterile plastic capped urine cups that are individually wrapped and sealed and sterile? The sterility is guaranteed.
Yeah.
Are you kidding me? And you don't have an evidence cooler? Who this day and age doesn't have evidence coolers?
Yeah, this was 2022. This wasn't in 1999. You know what I mean? It wasn't 1991. Even then, you'd still have it. But yeah,
I just don't understand any of this. Okay,
it's mind blowing. It's mind blowing. Let's let the rest of this play. And I know you were in Morocco when this was all unfolding, and you were pulling your hair out of your head. But thank God it all grew back, and you're back here on U.S. soil.
Plastic cups from a neighbor to
wearing a hat.
plastic. Officers described how they borrowed red.
If you guys didn't catch that, Ed said, I don't think it came through. He said, that's why I'm wearing a hat.
Because I pulled all my hair out of my head. I look like Ron now.
Oh my God. Bald is beautiful, Ed. All right. Let's back it up just a little bit. All right. There we go.
Officers described how they borrowed red plastic cups from a neighbor to collect samples of blood in the snow and then took them back to the Canton police station in a Stop and Shop paper bag. Officers say they didn't have anything else to collect the evidence, and so they had to improvise. The defense asked one of the officers if perhaps that created an opportunity for evidence tampering, but the prosecution objected. The judge agreed, and that question was never answered today in court. 2-9.
You know, go ahead, Ed.
If they don't have the sterile urine cups, everybody knows what a urine cup, right? If you've ever taken a drug test, they give you the cup, you open the cap, you go and take care of your business, right? Well, we use them in forensics all the time to collect biological samples and so forth, right? Especially in CBRNE, chem bio rad nuke explosive, but neither here nor there. You don't have them on scene. How far away is your equipment? Do you have them at your equipment storage in your police headquarters or wherever the crime scene unit is located? If they don't have that there, where could you go? Oh, the emergency room. Run to the emergency room, grab some cups, come back out.
Right. Yeah. And headquarters, Canton Police, by his own admission, Lieutenant Gallagher said was a mile to a mile and a half away from the crime scene. At 34 Fairview, you're a mile and a half from home base. You can't tell me that you don't have these supplies there. And if you don't, then your police department should be closed down. That's disgrace. I would not want to be a victim of a crime in Canton, because the way that they took on a dead police officer. Now, initially they had a dead police officer on that front lawn. They charged Karen Reed with his murder sometime later, right? But you process a crime scene for a dead cop this way. Ed, what do you think they're going to do for Joe Blow? Me, you, if we weren't police officers, what are they doing for Joe Q and Miss Citizen of Canton Police, of Canton, Massachusetts? What kind of investigation does the regular person get?
I have no clue. I mean, you would have to review all the previous crime scenes that these people have done. How much evidence was lost? How much out of protocol are these people practicing forensics? Okay, you know, the blood is frozen. It's frozen on the snow. It's not going anywhere.
Right.
It's not going anywhere. Run to the command and get some cups, some sterile urine cups. If not, run to the hospital, get some sterile urine cups, and come back out and get your igloo cooler and pack it with ice and get it ready to transport these things as fast as you can to the appropriate laboratory.
And I want to ask you this question, and you know, I know the answer to it already, but Serenity RPH says, and a cop family in the house don't even come outside of their house. What the hell? I'm not
buying that. I'm not buying that. I'm sorry. I live in a neighborhood full of NYPD. Okay, you can't walk up and down my block in 3-block direction without bumping into a cop.
Right.
Okay. You know, when something happens in my neighborhood, everybody's out.
Right. But you have a dead NYP.
You got lights flashing outside. You mean to tell me that what do they got blackout curtains here, or is this like World War II and they're huddling from the blitzkrieg?
And they stuck with this in their testimony. Not only did Chris, his wife, testify that she didn't hear anything, the dog didn't bark. As a matter of fact, when I don't remember who it was, one of the other friends of the family came busting in. I think it was the sister-in-law came busting into the house because the front door was wide open. You usually leave your front door wide open, Ed?
No, I can't get past my house with Kara.
I get that their son, Chris Jr., his 23rd birthday party, and a bunch of kids were over during a snowstorm, drinking or doing whatever they were doing. Well, most of them said they weren't drinking, having a party at the house. But you're going to tell me that 4, 5, 6 o'clock in the morning, your house, the front door is not locked, and your dog doesn't bark. So the whole thing's crazy. But
what do I call my dog, Ralph? What do I call my dog?
Yeah, no, don't, because Carol, she's block watch.
What do I call her? I call her the window tough guy. She jumps on the sofa, looks out the window anytime there's somebody in front of the house, and she starts barking her head off.
Right. This whole thing is just so suspicious and so not right. A ton of super chats and people are chiming in. Catherine Joy. I know, Ed, go ahead. Go.
No, I mean, here, okay. I get, the EMS and everything, was working on him, brought the body to the hospital emergency room. Once he was declared dead, then I don't know what happened to Mr. Okeefe at the hospital and who touched him and who didn't. Those injuries that may have come from a dog, how much evidence was lost there? We're not swabbing those injuries and getting the DNA potentially from teeth of a dog or claws of a dog, and getting that potential DNA of that dog off of those injuries. Okay.
And they were not aggressive to try to find out that information, because if there was a good investigator on the case, and thank you, Cynthia, for the $20 super chat. She said they added involuntary to jury conference. Thank you both for your coverage. Karen is guilty, but the state did not prove it. God bless the Okeefe family. Hey, opinions like this we respect, because I respect both sides of this thing, right? But the job of the prosecution, the Commonwealth of Massachusetts, Adam Lally, his job was to prove beyond the reasonable doubt. The burden is on the Commonwealth. And he did not, in my opinion, and you guys let me know in the chat, he did not, by any close stretch of the imagination, prove beyond the reasonable doubt that Karen Reed hit John Okeefe with a car and left him to die in the snow. They didn't prove it. And I don't care what anybody thinks. If you look at this with common sense and you look at we're on day 6 right now. And in day 6, we're going to show evidence that was found in the snow that was recovered by Sergeant Michael Lank, Chris Albert's lifelong childhood friend. He found a glass in the snow that they claim John Okeefe had in his hand when he went to that location. Ed, I'm sorry I cut you off. Go ahead.
No, and that's great, because I believe the defense's accident reconstruction experts, and then the defense's pathologist, the Irishman from California. Well, actually, he was born and raised in Ireland, but came to California, and it was San Bernardino, I believe it was the pathologist there.
Right.
But his testimony was tough to listen to, because the man is obviously suffering some respiratory issues. But but he was spot on. Okay, and those two witnesses, I think, destroyed the state's case.
Right.
Okay. And again, the state was dealing with what we say, and what I keep saying, folks, crap in, crap out, right? If the investigation, the evidence wasn't handled properly, nothing the lab can do can fix that. Okay. And if the investigation wasn't done correctly, there's no way to correct it. There's no way to correct it. This is law enforcement malpractice, in my opinion.
And I'm glad you said it, Ed, because I have made that statement myself. But coming from somebody like you, who is a forensic and a CSI expert, again, I don't like to brag about you, but I do. You processed over 2,500 crime scenes in the New York City Police Department. You teach forensics worldwide. You're out there. teaching all different aspects of this business. And for you to call me and tell me that you're outraged and you're ready to talk about this, I just said to myself, you know what? We need to do this live stream tonight. And look who's in the chat. Ed, thank you for the $20. Miss Burkhart with Burkhart Law. She sends $20 in and she says, and she's a criminal defense attorney on the West Coast. Great friend of this channel. We've had her on. She's got a great channel. She's been covering this. I've been in her chats. She's been on this day in and day out, doing 5, 6, 7 hours, whatever it takes. She's on it. And she says, I've never seen a chain of custody failure this complete. You can't even conceive why this happened. Absolutely no need for it. Yeah. The family of John Okeefe. My heart breaks for them. They should really, after this is all said and done, I don't know what kind of recourse they could have, but I look at John's mother, and I look at his father, I look at his brother and the family, and the kids that he was left to take care of, his nieces and nephews. Those are the people who I feel so sorry for, because the police let them down. Ed, you said it so well. This is malpractice on behalf of a forensic team who's taxed with getting evidence and presenting it to prove who killed him. Now
It's not just the forensics team. The whole investigation, the text messages, the stupidness of that.
Yeah.
I know.
And our good friend, attorney Melanie Little, was in the courtroom last Friday, I believe, not this Friday, it's past a week before. She was in the courtroom. She got invited by Karen's family to come, and she sat right in the front row. Melanie was in court on Friday when Trooper Paul gave his testimony. So let's listen to day 6, and thank you to all who are here and for the super chats, and for, I like to look at the chat. I love to see what people are talking about. And thank you, Andrea, for the super chat. It's much appreciated. This is day 6, folks.
Police lieutenant took a broken cocktail glass out of an evidence bag and held it up for the jury. Lieutenant Michael Lank described spotting the glass in blood-stained snow outside a home in Canton, where John Okeefe's body had also been found.
It was on the left side of the property, about 8 feet from the road.
The cocktail glass seems to support the prosecution story that Okeefe had been out bar drinking with his girlfriend, Karen Reed, then came to the house in Canton and was killed by Reed, who allegedly backed into him with her SUV. A few days later, police found a piece of Reed's shattered taillight in the same spot.
I photographed the piece of plastic as it sat.
But defense attorneys have said Okeefe died from a fight. And when Lank first called police dispatch, that's what he initially thought too.
Your exact words to dispatch being, I don't know if he's been in a fight or whatever.
Correct.
Okay. Lank said he'd gone inside the home and didn't see any signs of a fight. Defense attorney Alan Jackson accused Lank of hiding the truth to protect the homeowners. Jackson brought up a 2002 bar fight where Lank had defended the homeowner's brother.
It was me coming to the aid of a citizen who was terrified and scared for him and his family on that night.
Who happened to be what?
Excuse me. Who happened to be Chris Albert.
Now, one key thing for the jury to decide will be exactly when and how Reed's tail light was broken. And late today, they saw some video that might help them make that determination.
Unbelievable, Ed. So he went into the house and talked to them, and no further investigation required. If your crime scene, now I'm going to put you on the hot seat. If this is your crime scene, do you go and try to get a search warrant to go in that house? Do you recommend that house be processed inside?
You got to have probable cause, right? We all know this. You need probable cause or consent, and it doesn't appear the Alberts would be giving you consent. And I don't know that they had reached probable cause yet. For that, but if they would have been able to identify the marks on the arm as potentially coming from a canine, injuries from a canine, and again, you got to look at the testimony too about whether these marks were ante-mortem or post-mortem. Okay, this is all stuff that could have led to getting a potential warrant. in there because they owned the dog. The dog was still there at that time. It was not rehomed or whatever the term is.
Right.
You know, I mean, look, there's only two reasons to alter a crime scene, right? Life safety and evidence preservation. Okay, that blood is in the ground, right? Boom, right. There's supposed to be glass, right? You know, not glass, but plastic from the lens of the Lexus, the rear tail light of the Lexus. Well, we have crime scene pop-up tents, right? We pop them up and they have sides. You put the sides up to protect everything there, and you tether it down with the rope and tent pegs.
Right.
I mean, you know, I'm sorry. I would have, if this was my crime scene, it would have been done totally different. And I'm not saying that to beat my chest. Any of my students, anybody that ever worked with me, anybody that ever trained would not have done that. Would not have done these things that were done here.
Yeah. Yeah. Schmitty says Ed needs a hyperventilation bag. Yeah. I agree. I think we all do, because when we go over this thing, it's just so frustrating. Day 7, the jurors are shown footage from inside a bar, inside actual bars, plural, because they went into CF McCarthy's and then they convened across the street to the Waterfall Bar and Grill. So the footage shows, introduced into evidence on day 7, shows Okeefe and his friends at McCarthy's pub. Reed was also seen in the video when she arrived, greeting John Okeefe with a hug and a kiss. Other footage from the Waterfall Bar and Grill shows Okeefe, Reed, and other members of the group after they moved across the street. Footage shows Reed left with 2 other women before Okeefe exited short time later, meeting Reed at the door and walking together towards her car. John Okeefe appeared to be holding something in his hand on the way out. Earlier in this case, the evidence of a shattered glass, as we showed in day 6. Lieutenant Lank pulling out that shattered glass from that brown paper bag. Let's take a look at this. And this is day 7.
Karen Reed and John Okeefe gave each other a hug and kiss at CF McCarthy's pub in Canton that night in 2022.
There didn't seem to be any tension between them and CF McCarthy's. Is that right?
Not that I recall.
The prosecution has said the couple argued that night and that Reed ended up backing into Okeefe with her SUV. But witness after witness who testified say they saw no trouble, not at CF McCarthy's and not at another bar called the Waterfall, where Okeefe and Reed went next.
It seemed like they were quite lovey-dovey at that point.
In fact, she says Reed kept praising Okeefe for taking responsibility for his orphaned niece and nephew.
She also wished that some of the family members would step up and help out a little bit more, because he took all the burden on himself.
Also at the Waterfall that night, Brian Albert and Brian Higgins. The defense has claimed they were part of a cover-up in Okeefe's death. In the video, Albert and Higgins seem to be play fighting. The video also shows Okeefe and Reed leaving the Waterfall bar. As they do, Okeefe appears to have something in his hand. The day before, in court, prosecutors showed a partially shattered glass found next to Okeefe's body. And prosecutors are laying out the case that Okeefe was holding that glass when he was allegedly hit.
So there you go. That's day 7.
And fingerprints, DNA, hair and fiber, blood, anything on that glass?
We heard nothing in regards to that at all.
Then we had the accident reconstruction experts for the defense built a pneumatic air camera, cannon rather, and fired a glass at rear tail light lenses at certain speeds. I think it was 35 miles an hour or 30 miles an hour or something to that effect, and were able to duplicate the damage to the lens.
Right. Yeah. And he was proud of that. We're going to play it. It's on day 29. We're going to get to that quick. Joey Brooklyn is in the chat, and so is Lieutenant Pete Pranzo, Harlem Raiders in the building. There he is, Lieutenant Pete and Joey Brooklyn, Allison B.D. Rochella is here. If Pete Pranzo's here, Rochella's here. Thank you for being in the chat, and thank you to the moderators, replay viewers. Evie323, she sent 5 DutyRon memberships. Thank you for gifting memberships. So kind of you. And thank you, Serenity, for becoming a YouTube member. Karen, a member for 4 months. She said, it's not just one thing. You can't explain it away. There's just the totality of everything that happened here in the Commonwealth's case and the way it was explained and put out right from anybody notice right from the beginning, opening statements by Mr. Lally, Adam Lally, were the most boring opening statements and opening that I've ever heard. And that was what set the tone for this trial. And it was just that same way going straight through. And I don't like to dog and jump on the pile, but he definitely shit the bed. And he did not present a good case, in my opinion. And if the jury comes back tomorrow with anything but not guilty, I would be shocked.
Well, like I said, crap in, crap out. Okay. I mean, he was handed a bag of shit.
Yeah.
Well, let's be honest about it. Okay. One of the most unprofessional investigations I've ever seen.
Ever.
Okay. And it's a fellow law enforcement officer that's lying dead here on the lawn.
Yeah.
Okay. And that's why, I mean, the victim will not get justice from this trial. Okay. And we'll never know the truth of what actually happened here.
Yeah.
She may be totally innocent.
Yeah.
On the other hand, she may not. I don't know, because the investigation was such shoddy work. We'll never know what really happened.
Never, ever. Yeah. I'm glad that she's here in the chat, Miss Burkhart. She said he refused to commit to a theory of the case. Just there will be evidence. And we saw a bunch of presented shoddy evidence, stuff that a reasonable juror would say, who does that? How does this happen? How does a leaf blower come into play when you're trying to clear a crime scene? And I got to ask you, because we're getting deep into this thing. And I asked you this on day 5 when this happened. And I want to put you again on the hot seat. If you're on this case and you have potential evidence is in the snow, what, if anything, would you use to collect this evidence, and how would you go about tackling it in a snowstorm with wind blowing and so forth?
Listen, there's several methods that can be employed here, but again, I don't think they have any of them to do it. So you put your tents up, right, in a specific area. And then just like you know, if you have like a clandestine burial grave, you start sifting the soil. You'll take the soil, just like in a post-blast investigation, you'll start sifting the soil. You create a clean work area, put a tarp down, then you put your sifters on top of it. Then you get you get 5-gallon buckets of soil, and then you put it into the sifters. Well, you can do very similar things here with snow. Okay. Now, you don't use a snow blower. First, you do non-destructive search methods first, right? You use infrared, you use thermal imaging, you use metal detectors, depending on what kind of evidence you're looking for, okay? You're looking for trace transfer evidence like glass, like you grid the location out. You're looking for, particles from a vehicle if you suspect this, and you grid the area out, and then you start shoveling the snow into the 5-gallon buckets. You bring it into the tent, and then you slowly start to introduce heat and melt this, and you sift it in through filters, and you collect what's left over. You don't use a leaf blower to blow trace transfer evidence like hairs and fibers away and other things. Yes, I understand it requires work, but that's what we get paid for. I remember I told you folks, I get paid to be anal, right? I'm so anal, I shit diamonds. Okay, that's my job, to leave no stone unturned. Okay. Gnarly. Thank you, Spicoli. But the point is, there's only one way to do the job, and that's the right way. It takes less time to explain why you did something right than why you got everything wrong.
Amen, brother. Amen. I couldn't have said it any better. Here we go. Let me just make sure I got this right. Day 8. Day 8, we're almost halfway. Well, we're not even halfway through, but let's let this roll.
Ben, good evening. The Alberts who testified here today are not the same Alberts who owned the house where John Okeefe died, but they are closely related. And according to the defense's narrative, closing ranks.
But the truth will help you God.
Yes, I did.
Thank you.
On the witness stand, Chris Albert and his wife Julie both testified they were out drinking that night at the Waterfall Bar and Grill and remember John Okeefe coming in with Karen Reed, who arrived, they said, with a drinking glass in her coat.
I think I laughed and said, made a comment like, "You're crazy," or something, just because she walked in with a glass.
Neither Chris nor Julie Albert went to an after party at Chris's brother's house, where O'Keefe's body was later found lying in the snow. But their teenage son, Colin, he did go, and during cross-examination, defense attorney David Yannetti suggested Colin and Okeefe didn't get along.
John Okeefe told you that Colin used to flip him off, correct?
Not correct.
And say F you to him.
Never.
The defense is trying to make this connection. The owner of the house at 34 Fairview Road is ex-Boston police officer Brian Albert, who has a brother, Chris, who is married to Julie, who is friends with Courtney Proctor, who is the sister of Trooper Michael Proctor, the lead state police investigator on the case.
Were you using Courtney Proctor as an intermediary to communicate with Michael Proctor about this case?
Objection.
I'll allow it. No, I was not.
The defense produced phone records showing Julie Albert and Courtney Proctor spoke by phone the day Reed was arrested and the day she was charged in court.
What did you discuss?
I don't recall.
I don't recall. Did you see how she looked to the prosecutor, Lally, for him to help her? And then he didn't help her and she said, "I don't recall."
You know what? I was discussing this testimony, not hers, but per se, but in general, the testimony of the law enforcement officers. You know how many times they said, "I don't recall, I don't remember"?
A lot.
Oh my God. And it was to me that, they were prepped to say that by the prosecutor. Okay. Yeah. And, because so many law enforcement, so much of the law enforcement testimony from various officers was, "I don't remember, I don't recall."
Yeah. Yeah.
And you know who uses that, right? People who use that so that they don't get charged with perjury.
Correct. We heard it in the Iran-Contra hearing with Ollie North, right? There was a lot of "I don't recalls."
Well, I mean, we can get into political cases where this happens all the time. Okay. Yeah. All right. But, but that's neither here nor there in terms of these cases, but it is a tactic to keep yourself from being, from perjuring yourself on the stand and giving testimony.
Yeah. She looked, I'm going to put this right on here. She's side-eyeing Lally to come in with an objection, and he didn't, which he didn't do a lot of that during this trial. But just watch her face here. You guys can see it, and then we'll move on.
In court.
What did you discuss?
See who she's looking over?
Oh yeah, she's got the right eyes there.
That's right where he is, and she's waiting for him to say objection, but he didn't. And then her next thing was, "I don't recall."
I don't recall.
See that long pause? Yeah, that was her waiting for him to say objection, Your Honor.
Yeah.
I don't recall.
Shady shit, ladies and gentlemen. This is like, and I'm retired like 13 years. This is the worst I've ever seen. This is the worst I've ever seen. Day 9, owners of the home where Okeefe was found testified. Nicole and Brian Albert owns the home at 34 Fairview and were put on, were part of the group that was out drinking with Okeefe and Reed on the night of the snowstorm. Several people were invited back to the Alberts' home after leaving the bar, but they testified that neither Okeefe nor Reed ever showed up. They never showed up. And everybody testified that John Okeefe never went into that house. Everybody was on it. Everybody was on that narrative that testified. Nope, never saw him in the house. Never came in the house. Let's take a listen to this.
The prosecution called Nicole Albert to testify about how she'd been part of the group out drinking that night with John Okeefe and Karen Reed.
I had never met Karen, and I'd only met John once or twice.
After leaving the bar, the Alberts invited some of their family and friends back to their house at 34 Fairview Road. But Nicole Albert says she never saw Okeefe and Reed show up.
No, they never came into my home.
There you go.
I didn't even realize that was happening, that they had any intention to come.
Prosecutors say Reed backed into Okeefe with her SUV. The defense says he was killed inside the house during a fight and dog attack. During cross-examination, defense attorney Elizabeth Little asked why the Alberts got rid of their German Shepherd mix named Chloe 4 months later.
I did not get rid of my dog. I rehomed my dog.
Why?
I do.
Why did they rehome the dog 4 months after this incident?
Okay, remember what I tell when I tell our audience of various forensics, what's one of the first pieces of forensic evidence that gets destroyed at most crime scenes is footwear impressions. It's snowing out, right? Wet shoes, okay? If you're going into somebody's home with wet shoes and you're not taking them off immediately and you're walking around maybe a foyer or a mud room or something, you know, that was probably evidence that was lost here too, potentially. And he was out of a shoe.
Yeah,
they found
one
the shoe,
shoe,
right?
Yeah.
Okay, and you know, it's socks are made of fabric, and there's hairs and fibers. There's fibers from the socks that could have been transferred to the inside of the house, if in fact he did go in there. But it could have been some evidence that was looked for, and again, it wasn't looked for because the house wasn't searched.
Yeah, and Gigi says it good. Get rid of equals rehome. Same thing. Get rid of, rehoming, same thing. And it's funny because her husband was asked to preserve his phone. And we're going to hear him now testify that it was his birthday. And, you know, he was due for an upgrade. So he figured it's really not that important to preserve my current phone for the prosecution and for various agencies that are investigating this thing. I think it was the FBI. I'm just going to go get a new phone because who cares about John Okeefe, police officer John Okeefe? I'm just going to get rid of any evidence I have and get a new phone. And that to me was just shocking to hear that. How nonchalant.
It's my birthday.
Yeah, it's my birthday. I was due for an upgrade, for crying out loud. My phone was shit in the bed.
Cole Albert, her husband Brian, took the stand. Like Okeefe, he was a Boston police officer. He explained why after O'Keefe's body was discovered, he never went outside.
It was a snowstorm at that point. They were trying to conduct an investigation, and I didn't want to interfere with it or have anything to do with it.
Sort of a side issue in the Reed matters.
With the jury out of the room, prosecutors asked for Aidan Kearney, the blogger known as Turtle Boy, to be excluded from the courtroom because he's facing witness intimidation charges in connection with the case. The judge said Kearney will have to wait outside during certain witnesses' testimony. The judge said that Kearney's presence might have a chilling effect on those witnesses' testimony. Brian Albert will be back on the stand.
All right, so the next one is Brian Albert. Let's get right to that. Ed, anything about him getting rid of his cell phone seem a little shady to you?
It definitely seems shady, but you know, again, with this day and age and the way the cell phone data is captured, and there's plenty of information to find.
Right. But it was never brought up in court. It was never brought out, and that leads me to believe that maybe there wasn't anything on it, or maybe there was, and they just didn't want it.
There was no text messages. There was no phone calls. They did they do any of this stuff? I didn't hear anything about it.
Day 10, ladies and gentlemen, day 10 of day 20 of 29 days.
Defense attorney just came out, the lead defense attorney, and said at times today he felt like a prosecutor. That's because even though Karen Reed is the only one on trial here, the defense is trying to shift the blame.
Let's get this on the record.
Brian Albert's experience testifying as a police officer showed in court as he remained calm during cross-examination and insisted John Okeefe never entered his home.
Absolutely not. I wished he had.
Prosecutors say Karen Reed killed Okeefe in front of Albert's house with her SUV. But defense attorney Alan Jackson has said Okeefe was killed in the basement during a fight and dog attack, and Jackson showed jurors the path between the basement bulkhead and where Okeefe was found.
Have I boxed before? Yes.
But Albert said he and his friend Brian Higgins were not boxing, just fooling around the night before while out drinking with Okeefe and others. And when Jackson asked why he got a new cell phone the day before a judge ordered him to save his old one, Albert answered this.
September 4th was my birthday. The phone was broken and failing. I had planned on getting a new phone, and that just happens to be the day that I got it.
Oh, hell no.
That just is just amazing to hear that. And why didn't the judge, Judge Beverly Canone, why didn't she do anything about that? That he just completely disregarded her order to save his phone. That's it's just amazing to me, and I don't think I've ever gotten an answer to it. I looked to see what the answer was, but oh, look at this. Attorney Burkhart says Brian Higgins extracted his own phone on FBI equipment. What? Who does that, Ed?
Exactly.
This whole trial, this whole group. I mean, listen, they were down here for Officer Sanchez's funeral, right? They were down here that weekend in 2022, and they all came down, and they I think they took a train or whatever, and then they drove back in a department vehicle with one of these guys, and it just amazes me the things that happen in this thing.
I know I see some things in the chat, but hey, that has to be answered out. How did that occur? Okay, I don't care what side of the fence you're on in this case. I'm on the side of the victim. Okay, there's no justice here for that victim. But that particular, if that in fact is true, that has to be answered out.
Yeah, 100%. I don't think we've heard the last of this because there's a lot of explaining to do here.
Albert answered this.
September 4th was my birthday. The phone was broken and failing. I had planned on getting a new phone, and that just happens to be the day that I got it.
After Albert left the stand, two of his children testified. Brian Albert Jr. remembered looking out the window that night and seeing a dark SUV like Reed's.
The last time I looked out the window, it had moved further down, closer to, I'll say, the flagpole.
Who is Katie McLaughlin?
Katie McLaughlin is one of the EMTs who arrived on scene and who previously testified she heard Reed say repeatedly, "I hit him." But the defense says McLaughlin changed her story because she and Caitlin Albert are friends. Caitlin says they're not close.
I can't think of a time, possibly ever, where her and I ever hung out one-on-one or individually.
And that was a blatant lie. And it was shown with pictures of them together in bikinis and a hot tub on the beach. So this gets as close to perjury as possible for.
What do you mean as close? She just perjured herself.
Yeah.
Okay. And if the defense has that evidence, or they should have
had
for a sidebar and went up there, and she should have been taken off the stand in cuffs.
Yeah. These two bikini clad together out at different places with groups of people it wasn't just them side by side, but with groups of people. And it was all brought to light. It was all brought to the attention of the judge. So things that make you go,
Caitlin says they're not close.
I can't think of a time, possibly ever, where her and I ever hung out one-on-one or individually.
Now, the defense says it has been deluged, that's its word, with pictures showing Caitlin Albert and Katie McLaughlin together with other people. The judge says she's going to take a look at those pictures and decide which ones, if any, the jurors will see tomorrow.
Yeah, so she looked at it and nothing came of it. But here we are, day 11. Albert, family friend, testifies about a black object in the snow. You know what? Let's do it. It's only 1 minute and 56 seconds.
Who had gone to that house in January of 2022 for a birthday party. She was one of the last people to leave the party and says she saw something as she was pulling away. Juliana Nagel was in the backseat of an SUV pulling away from 34 Fairview Road in the middle of the night when she says she glimpsed something through the window.
Something out of the ordinary, like a black blob in the ground by the
black blob.
Nagel said the object was about 5 to 6 feet in size. Nagel's friend, Sarah Levinson, was also in the car and says Nagel at the time did mention seeing something, but didn't say what.
I asked for clarification.
Did you receive any further clarification?
No.
Under cross-examination, Nagel admitted she was drunk that night and didn't recognize the object they passed as a body.
Did not tell Matthew McCabe, hey, stop the car, correct?
I did not know.
The next morning, John Okeefe's body was found at that same spot. Prosecutors say Karen Reed backed into him with her SUV. Nagel also remembered seeing an SUV similar to Reed's pull up at that same location.
I saw it pull up, stopped, pulled up again, stopped, pulled up again by the flagpole, stopped. That's all I saw.
The defense has said Okeefe was killed inside the house during a fight and dog attack. But so far, 6 witnesses who were there that night have all testified they never saw Okeefe or Reed come inside.
Are all of these people lying? Who are you talking about?
Is
You gotta be
Sarah
a little bit
lying?
more
Is
specific
Sarah
than that.
lying?
Is Sarah lying? There are parts of her testimony that are not credible. It's not a matter of all people doing anything. It's a matter of whether or not the evidence on its own can stand the test of scrutiny.
No, we've yet.
Very well said, defense team for Karen Reed. I want to move it along because I want to get to day 29. Here's just a little bit more of an emotional day of day 12. And this is just a minute.
Harassment. Can I have a moment, please?
Sure. It has been the most emotional day of testimony so far. News Center 5's David Bienick live at the courthouse in Dedham with this, David.
Erica, that young woman you just heard from is a family member describing some of the harassment she says her family has received from Karen Reed's supporters. You're going to hear more from her coming up tonight at 6. But first, there was also important testimony here today about Reed's SUV and when exactly John Okeefe got out of it. Ryan Nagel had gone with 2 friends that night to pick up his younger sister, Julie, from a party at 34 Fairview Road.
Because she shot me a text asking for a ride.
As Nagel pulled up in his friend's pickup, the 3 of them saw a black SUV, similar to Karen Reed's, parked and still running in front of the house. In fact, Nagel's girlfriend had first noticed the SUV as they turned onto the street with 2 people inside.
I noticed a male and a female in the car.
The pickup then pulled up behind the SUV, and Nagel's sister came out but decided not to leave and went back in. As the pickup pulled away, it went past the SUV, and Nagel says he noticed an interior light was on and a woman in the driver's seat.
Seemed like she was looking straight ahead with her hands at 10 and 2 on the steering wheel.
But none of the 3 people in the pickup say they saw the male passenger at that point. The defense has said that Okeefe had gone inside the house where they say he was killed in a fight. They suggested Okeefe had gotten out of the SUV without the people in the pickup noticing.
You were not monitoring what was going on inside or outside that black SUV, correct?
Correct. But the prosecutor suggested Okeefe was still in the SUV at that time and that the people in the pickup simply didn't see him.
And fair to say that if a 6-foot man had walked from the SUV to the house, is that something that you think you would have seen?
Sustained.
Gets crazier and crazier as the days go on, Ed. We're on day 12. Day 13 is, again, Colin Albert. He had the bruises on his hands. I kind of want to play this. It's 1 minute and 44 seconds. And then we're going to get to Trooper Paul because we got a lot to say about that.
Step back on the witness stand, defense attorney Alan Jackson was confrontational.
Do you remember anything about this case?
Jackson showed a picture of Albert taken less than a month after John O'Keefe's death with bruises on his knuckles. The defense has...
Yeah, that right there was big for the defense.
Defense has said Okeefe was killed during a fight. Albert said he got hurt when he slipped on a driveway.
And you injured your right fist, just the top of the knuckles on your right fist when you fell down.
Correct.
Seriously?
The defense also played social media videos of Albert making profanity-laced comments to other teens while in high school.
Was that a threat?
Yes.
The prosecutor called it a juvenile beef about girls. Albert said he'd never actually been in a fight, except maybe with his brothers. Jackson then asked about Albert's ties to Trooper Michael Proctor, whom Albert knows through his family, and who Jackson suggested gave the Alberts preferential treatment.
Was it antagonistic or confrontational?
Can you use different words, please?
Sure. Was he being mean?
No.
Okay.
Colin, do you want to say what it was like for you today?
Albert left after more than 2 hours of cross-examination, during which he was asked not once about the night of O'Keefe's death.
This has turned into the defense of the Alberts rather than the prosecution of Karen Reed.
No one other than Karen Reed has ever been charged in connection with this case. Tomorrow, we expect to hear from Jen McCabe. She was one of 2 women who were with Karen Reed the morning that John O'Keefe's body was found.
Ed, a lot of people are asking you about the knuckles and those bruises. Just 2 months after, what's your take on that, Ed?
Well, it's definitely circumstantial evidence. I mean, there was no testing done of him that night. There was no swabs or anything taken to see if there was a mixture of DNA on those knuckles. And I don't know many people that fall down and don't put their hands out like this to stop themselves, but put their hands like this and then damage their knuckles. I've never seen that in my life. And usually, this area right here will be damaged, in falls, because your natural instinct when you're falling is to put your hands out, not to hold, just the knuckles get damaged.
Yeah. And that was just kind of blown over in this trial, and they just continued on. Day 14 is about Karen Reed yelling. A witness said Karen Reed yelled, "Did I hit him?" Jennifer McCabe and her husband, Matt McCabe, both testified that they had seen Reed's black SUV at 34 Fairview. Let's take a listen to this. This is Will Farrell lookalike. And this testimony was interesting to hear, to say the least.
It was a loud, Jen.
That was the screaming on the phone that Matt McCabe says he and his wife Jen woke up to that morning. It was Karen Reed calling to say she couldn't find her boyfriend, John Okeefe.
She didn't know where John was, and the last time she saw him was at the waterfall.
Matt McCabe says he thought that was strange because he remembered seeing Reed's SUV after they were all at the waterfall bar when they'd all gone to a private house for an after party.
And I heard the response of, I don't remember going there.
During cross-examination, the defense read text messages McCabe had exchanged with family members a few days after O'Keefe's body was found lying in the snow.
That was you talking about how you should all get your stories straight, correct?
No, John never went in the house. It's not a story, it's a fact.
Later, McCabe's wife, Jen, took the stand. She described driving Reed to look for Okeefe that morning, first at his house, where Jen McCabe says Reed pointed to her broken taillight.
I saw that there were missing pieces, but there was also snow covering it.
Then to 34 Fairview Road, where Jen McCabe says Reed was the first to see Okeefe at the spot where prosecutors say hours earlier, Reed had hit him with her SUV.
All of a sudden, Karen starts screaming, there he is, and she's banging to get out.
So that was testimony from day 14. It continues on. Cross-examination, the confrontation over phone records in day 16. I want to speed through this, and I'm going to link this in the description so you guys can go all watch it. This was damning testimony. Day 17, the romantic kiss and the flirty texts between ATF agent Brian Higgins and Karen Reed.
Yes, both the prosecution and the defense are trying to use this witness' testimonies to further their own versions of the case. Now, the witness was Brian Higgins. He's an ATF agent, and he says he was also friends with both John Okeefe and Karen Reed. He says a few weeks before Okeefe died, Reed started sending him text messages, including, "You're hot" and "You're just my type." Higgins says he was also attracted to Reed, but he wasn't sure where their relationship might be going. He says he'd gone to Okeefe's house around this time to watch a Patriots game, and that as he was leaving, Reed walked him out and did this.
The defendant kissed me.
And how did she kiss you?
Not like a friend.
Lip to lip, is that fair to say?
Yes.
They drove back with you because of the storm.
Now, the prosecution is trying to show that Reed and Okeefe's relationship was in trouble and suggested that might be a motive for why she allegedly killed him. Under cross-examination, the defense suggested Higgins was the one pursuing Reed and said that she had started, quote, ghosting him. The defense wants to suggest that it was Higgins who felt.
All right. Day 18, Okeefe's niece testified about their rocky relationship. The prosecution continued to try to tear down Karen Reed and John Okeefe's relationship. And then here we have at day 19, car crime scene evidence takes center stage.
Good evening. This trial has definitely now moved into the physical evidence phase. And the prosecution is certainly laying it on, piling on with dozens of clues that they say point to Karen Reed's guilt. A team of searchers used shovels and rakes to...
Ed, I mean, I'm glad that I'm showing this because this is the state police, Massachusetts State Police. They're using shovels and rakes here. Did you see this, or is this first time seeing it?
No, I've seen portions of it.
Okay, let's let the rest of this play.
Reed's guilt. A team of searchers used shovels and rakes to sift through the snow at the spot where John Okeefe's body had been found. They say they found a half-dozen pieces of red and clear plastic, which the prosecution says came from the taillight of Karen Reed's SUV after she allegedly backed into Okeefe and killed him.
Tully had informed us that the victim in this case was struck by a vehicle. He believed there would be broken pieces of taillight in the area. He also stated the victim was missing his sneaker.
The searchers also found that sneaker right next to the curb. The defense has said the evidence was planted at the crime scene by dirty investigators, and defense attorney David Unetti suggested they had plenty of opportunity.
At the time that Lieutenant Tully first called you, were you aware that no one from law enforcement was controlling that crime scene?
Objection.
I'll allow it.
I was not aware of that, no, sir.
Later, a state crime lab analyst testified about the damage she found on Reed's SUV, including not only the smashed taillight, but also scratches. And she says she found what she later determined to be a single strand of human hair.
That is a picture of the apparent hair I noted in the area.
The analyst also examined the sweatshirt Okeefe had been wearing when he went out drinking with Reed the night before. She found red-brown stains on it and 13 rips and tears, especially on the right sleeve.
Are you able to tell from your examination of those fibers and of those clothing materials sort of what caused those tears and cuts?
No.
Wallace?
Any DNA workup on it?
Apparently not. I think that I think I remember from my memory that they said they swabbed it and then they weren't able to retrieve any DNA, dog or human from.
What happened to the hair that was on the taillight? The one hair, did they do a workup on it?
I believe they did, and I don't think it came back to John. Or did it come back to John Okeefe? I don't know. Maybe someone in one strong hair, says Becky B. I don't know. But
well, the defense doctor, emergency room doctor from California, came out and said it was canine marks on the clothing and on the skin.
So there you have it. So this is surveillance video from with Karen Reed's vehicle. I'm going to skip over that because I want to get to some of this here. Defense questions mirrored video. This is the video inside the Sally Port where they showed the driver's side and then they flipped it to show the back side, the passenger side. And also it's alleged that Trooper Proctor was there inside that Sally Port as well. There's a lot of shady shit going on in this thing. And we got more questions than we got answers. And here it is. Day 22, this regrettable text message from Trooper Proctor, and seeing him on the stand really just turned my stomach. I don't know. Let me know what
lead investigator in this case admits that he wrote.
Let me go how you guys feel in the chat about Trooper Proctor.
And offensive text messages about Reed while working on the case. Trooper Michael Proctor says he's sorry for the language he used, but that he still believes Reed is guilty. News Center 5's David Bienick has been covering this from the beginning. He's live tonight once again outside the courthouse in Dedham. David, good evening.
All right, so there you go. Carly, who I trust and I know has been following this thing closely, she says the taillight was embedded in his sweater and the DNA on the taillight and hair was John's. Mm-hmm. So there you have it.
Okay.
Ben, good evening. We already knew that Trooper Michael Proctor is the subject of an internal investigation by the Massachusetts State Police. Today, Proctor himself revealed actions that he says he now regrets when he was forced to read his own words.
Keep your voice up loud, please.
Trooper Michael Proctor's voice got softer and softer each time he read one of the text messages he'd written about Karen Reed while investigating the case.
She's a whack job.
Proctor also used more offensive terms to refer to Reed as he communicated with friends, family, and state police co-workers. While searching Reed's cell phone, he texted this to another trooper.
No news so far.
Proctor insisted his comments did not influence how he handled the case and the conclusion that he reached that Reed is guilty of killing her boyfriend, John Okeefe.
The rest of the unprofessional and regrettable comments are something I'm not proud of, and I shouldn't have wrote in a private or any type of setting.
Ms. Reed, do you want
Pardon my French, but you're an asshole.
to say anything about the language you heard?
I'd like the state police to say something about the language they've heard.
Earlier, Proctor showed pieces of a taillight from Reed's SUV, which he said he'd found. The defense has accused Proctor of breaking the taillight himself, then planting the pieces at the crime scene.
I think you got to get good insight into his true bias, his true character. Yeah, he's a pig.
Is there anything in those messages where he says she's innocent and that he's trying to frame her?
Everything in the text messages show his bias.
The defense also made the point that none of Proctor's co-workers on the state police called him out for the language that he was using. The defense is not yet done with much.
Yeah, it was disgusting what he said about her. He talked really derogatory about Karen Reed and just really horrific. I'm going to skip over this part. Day 25, crash expert says injuries consistent with SUV strike. I do believe this day 25 is Trooper Paul. So let's take a listen.
Here's Karen Reed's Lexus SUV after investigators brought it to the Canton Police Department to test its speed and braking, as well as the backup camera screen on the dashboard.
Everything seemed to be working properly.
Trooper Joe Paul testified he also pulled information from the Lexus's onboard data system and said it showed the driver had put the vehicle in reverse, slammed the accelerator 3/4 of the way down, then went backwards at up to 24.2 miles per hour. He said hitting a person at that speed would likely have caused the kind of injuries he saw on John Okeefe.
Those are something that would be consistent with this particular case with striking the Lexus.
Earlier, an expert for the prosecution testified that she had tested Jen McCabe's cell phone data. McCabe has previously testified that Reed asked her to search Google for hypothermia on the phone after Okeefe was found. And the defense has said that the search was done in the middle of the night.
There is no indication of a Google search at or before 2:27 a.m.
Before the witnesses, the judge brought in a juror for private questioning, then brought in 3 more jurors and questioned them one by one. Then the judge dismissed the first juror for what she said were personal reasons.
It doesn't change anything. As the judge said, we just move on, and that's why we have extra jurors.
In Dedham, David Bienick, WCVB News Center.
So there you have it, Ed. I see you're highlighting a couple of questions here in the chat.
Yeah, there's some mixed information coming out here, that the taillight was touch DNA, not blood. There was no blood found on the taillight. The clothing wasn't packaged properly, apparently. But that trooper there who did the accident reconstruction, I didn't see his I didn't see where the prosecutor laid a foundation for him to be made an expert in accident reconstruction. I did hear later in some cross-examination about some of his training and his lack of knowledge on physics. And I was kind of shocked about his inability to testify on some basic Newton's laws, if you will, in motion and force and kinetic energy and all these different things. I do have a background in this, but he doesn't. Apparently, he just has an associate's degree, and his credentials, in my opinion, were very lacking in this area, in this field. And apparently, he has some training. I don't know the extent of all the training. I am not an accident reconstructionist. That is not my bailiwick. And like Clint Eastwood said, man's got to know his limitations, and you never stick your neck out beyond what your area of expertise is to have somebody chop your head off. Okay. Right. And in this case, I think he just did that.
Yeah, I'm going to play a little bit because it is cringeworthy. And, some people are saying in the chat, I felt bad for him. I felt sorry for him. But when you have a case like this, where it involves a police officer who was allegedly murdered, you need to put your best people on it. So shame on the Massachusetts State Police for putting someone who's incompetent to be cross-examined by a defense attorney who, in this case, seemed like he had more knowledge than Trooper Paul. And that, to me, is a travesty of justice.
Well, he did his homework. Let me just put it that way. The defense attorney had his physics down. Okay. And, you know, so he had done good prep work to cross-examine Trooper Paul.
Let's listen.
That key cycle would include the time in which Trooper Proctor had possession of that car, correct?
No.
Assuming my hypothetical.
Your hypothetical?
Yes.
If that's hypothetically how it works, then yes.
Then what? What?
If that's hypothetically how it works, then yes.
On June 9th, 2022, you were asked by a grand jury whether you knew or had done any scientific testing to determine the distance a body would actually.
And that noise you're hearing is him breathing into the microphone, people. He was that distressed that he was breathing really heavy. And he did it throughout the whole thing. So the Alan Jackson goes on to slay him like really bad here. And I'm going to speed it up.
Travel. Struck by a vehicle. Remember that?
Not that specifically. Not in that way.
Do you remember answering that you had not, I'm just paraphrasing, that you had not done you hadn't finished your report yet?
Why don't you show him? He said he didn't remember it that way.
Well, that answers that question.
There you go. Yep.
Yeah.
Yes.
Take a look at middle of the page. Your answer starts at about line 12, but the question above it is probably informative. You have that in mind?
Yep.
Yes.
I actually took notes on this guy's testimony.
You were asked, does that remind you that you were asked by a grand jury if you could calculate how far a body would move having been struck by a vehicle?
Yes.
And you indicated, quote, yeah, there's certain calculations we can do with that, would figure out if you say if the car backed up, hit somebody, and then they go a certain amount of distance, and it's based on miles per hour, speed of the vehicle, striking vehicle, and stuff.
And stuff.
Yes.
What did you mean by stuff?
Oh my God.
I don't know.
He said, I don't know.
Right. He doesn't know the formulas. He doesn't know momentum equals P. He doesn't know mass times velocity equals momentum. He doesn't know any of the physics and engineering involved in this. He couldn't even define kinematics. Okay. I mean, which is like a huge part of accident reconstruction.
Calculations would be based on miles per hour and stuff. Did you ever do any stuff to test that? Grand jury's question.
No, we cannot calculate anything from this collision.
Say that one more time.
We cannot calculate anything from this collision.
Who's we?
I'm sorry, me, the role me.
Well, you know John Okeefe's weight, right?
What's that?
You know John Okeefe's weight, 217 pounds, right?
Yes.
Did you know that?
I don't know his weight, no.
You know the weight of the vehicle?
Yes.
What's the weight of the vehicle, gross weight?
What's the gross weight?
Yeah.
I think it's approximately 7,300 pounds.
Yeah. Were you able to calculate the mass of the vehicle?
I did not calculate the mass of the vehicle.
Well, you told the grand jury that you were planning on doing that kind of stuff to calculate how far.
I'm sorry.
Travel being struck at that speed.
Yeah, I'm going to stop it.
He doesn't know the definition of mass. He doesn't know the weight. He doesn't know the physics that are involved here. He doesn't know the four formulas or of kinematics. What what made him an expert in accident reconstruction? See, this is a key example, folks, of bad forensics. Okay, sometimes a little knowledge makes a person very dangerous.
This went on for 24 minutes, Ed.
He was way out ahead of his skis. Okay.
Ed, what's your feeling? People in the chat are saying they felt sorry for him. They feel bad for Trooper Paul.
No, he put himself in this position.
I don't feel bad for him. I have a lot of empathy, and I want to say this with us on screen, Ed, together. We both are very empathetic, right? But when it comes to this shit, you need to have dot your I's and cross your T's. And if you don't know what you're doing, then you better learn.
Well, listen, based upon this testimony, if he was involved in any other criminal cases, if I was a defense attorney, I'd be reopening up all these cases.
Absolutely. This is an eye-opener for Massachusetts State Police. And think about this, ladies and gentlemen. If this was your family member who is dead, buried 6 feet under right now, would you want a guy like this testifying at a trial that's unsure of everything that he's saying and everything that he did?
So, I mean, who qualified him as an expert? Did the state police qualify him as an expert in accident reconstruction based upon what? Two training courses or whatever he took? I mean, does he have a certification from a forensic entity that does accident reconstruction, who tested him on his knowledge and his math and his ability to do these calculations? I mean, does he know what final velocity is, displacement? Does he know what it equals in final velocities and all of this, momentum, kinetic energy? Does he know any of these things? Okay. It just seems like he doesn't know the math. He doesn't know the engineering involved in any of this.
Yeah.
And here he is saying, his hand got hit. He did a pirouette. He turned around and then, he hit his head. What is going on here?
This goes on for 24 minutes. This video is 24 minutes long, and the whole thing is him being cross-examined by defense attorney Alan Jackson, who is, in my book, a rock star when it comes to defense, being a defense attorney. And if I ever needed a defense attorney to represent me, I'd want somebody like him on my team. So it doesn't get any worse than this, ladies and gentlemen. And we call the balls and strikes. I love that saying, Ed, that you say, we call the balls and strikes. I wish that we didn't have to talk about this, but we would be remiss if we didn't call this out as a travesty, a disgrace to all good investigators, accident reconstruction, crime scene and evidence collection folks. There is many great men and women out there who are on point with this stuff. And you're looking at Ed Wallace right here. This guy is a rock star when it comes to crime scene and evidence collection. Basically, what we saw here right across the board is shoddy police work from beginning to end. Ed, correct me if I'm wrong.
Yeah, no, I'm 100% in agreement with you on this. But let me tell you, folks. In 2009, there was the National Academy of Science did a report on forensic science, and it was devastating to the forensic community. Okay, and there were those who said that police officers should not be allowed to do this kind of work, that they're not scientists, and they can't be trained and gather the expertise. They don't understand the scientific method. And I disagree with this wholeheartedly. Yeah. Okay. And in fact, I was involved in at the American Academy of Forensic Science. There were several discussions and group discussions about this by a panel of experts. And there was open mic session where, they were saying, we need to take all the forensics and crime scene stuff away from cops and just, graduates from science, forensic science colleges with degrees, allow them to do the work. Because, and I got up to the mic and there was several people on this panel that knew me. And I said, are you telling me that I'm incompetent and I can't do this job as well as you all?
Yeah.
And one of them worked with me, and one of them was a big name in the forensics. And anytime he got hired by the prosecutor's office in New York to do work, to review cases, he would ask for me to be his assistant. And I said, so obviously, if the person is trained properly and is professional and goes, the extra mile to go out and get the certifications and get the extra training beyond what they're being taught by their agencies, then the job can be done properly. And the scientific method can be. I constructed numerous reconstruction tests. All right, I saw something, I didn't understand how it happened. I developed a hypothesis. I conducted controlled experiments, as you will see in the defense testimony by the accident reconstructionist.
Yeah, it's just crazy that that this is going on in 2022. Here we are looking at this ridiculousness. The Glara says, it's been a travesty of justice, and it's been obvious for over a year. That's why I tried to bring it to your attention. I guess it's safe now. Well, Will, I appreciate that comment, and thank you for being here. But Ed and I wanted to wait to see and hear everything. And today was the day. We heard everything. And we're not the type that are going to just talk on stuff until the whole case is presented. And that's what we waited for. And that's why we're talking about it tonight, because the Commonwealth has rested, and so is the defense. And what we've seen is nothing short of a joke. This case shouldn't even have been brought forward, in my opinion. I'm not an attorney, but based on what I've heard during the course of this lengthy trial, they got nothing but a bunch of hogwash here, and a bunch of lies and a bunch of nonsense in this case. Ed, you got something highlighted? What did I miss?
Apparently, this trooper trains other people, and he shouldn't be training anybody. Okay,
yeah, he should step down from his position.
When you're done in this business, if you screw up and your reputation is shot, you're done. You're done. Nobody wants to touch you. No prosecutor wants you to testify. Your supervisors should know that you're finished in this area of forensics and put you in another assignment.
Yeah. It's so true, Ed. It's so true. So here we go. I am going to call it here. Convict Ballerina says, what's your opinion on the DutyRon, guilty or not guilty? What's the opinion on this case? I feel that if this jury doesn't come back after getting the case tomorrow, and they won't need more than a few hours, not or less, to deliberate. I have a strong feeling that tomorrow we'll hear a not guilty verdict. And if it's not tomorrow, it would be the next day. It'll be Wednesday. That's my opinion. Opinions are like assholes. Everyone's got one, and I'll tell you, that's my feeling on it.
There's so much reasonable doubt here. I'll be miffed if it comes back guilty.
Let's look at the super chats and let's begin to wrap it up. I want you to just talk about before we wrap it up. Let's go to the super chats real quick. So Beckfest is here, a good friend of ours. She sends in $20. Thank you, Beck. She says, I'm late. Did I miss it? Or has Ed spoken on the blood pattern on the clothing? We saw them holding his John Okeefe's clothing up, police officer John Okeefe. And then she said, it took memoirs of the blood pattern, show you guys had this, and the story didn't add up. Watching every day on Melanie's. Tomorrow can't come soon enough. Ed,
see, now what happens with blood on wet clothing is, first of all, blood, the clothing is porous. It'll absorb blood. But then if the clothing is wet, when the blood is deposited on it, it gets diluted and then it wicks, and any pattern that might have been there, it gets lost. All right. So what I saw in that one shot of the clothing, the torn clothing, and you see all the blood down the front of the clothing. I can't make heads or tails out of what that is or how that was caused. But you could tell that the clothing was wet when the blood was deposited there, the way that it was diffused throughout the cloth. But I would like to look at the clothing underneath the microscope and get a better feel for what was going on there.
And Karen Nelson's member for 4 months. She said it's not just one thing. You can't explain it away. Yeah, we agree. Emily, thank you for gifting a membership. Appreciate that. Buffy says they swabbed the arm at the hospital, sent it to the UC Davis. No canine DNA. It's all a mess. Let's focus in on the Okeefe family with a heart. We can't blame the Alberts or Karen, in my opinion. Listen, we respect Buffy. We respect everybody's thoughts and opinions on this because there's always going to be two sides. There's going to be people who are for the prosecution and for the defense. And I can tell you right now that based on the evidence that was presented and how the evidence was collected and how this case went, the prosecutor, the Commonwealth, did not prove beyond a reasonable doubt. The burden is on the prosecutor. The burden is on this Commonwealth. And Mr. Lally did not prove his case beyond a reasonable doubt. And anybody that thinks he did, you're not watching the same thing or seeing this through the same lens that I'm seeing it. Ed?
Yeah, and the case wasn't properly investigated, so we can't blame anybody. And I mean, we don't know what happened to Mr. Okeefe. Okay, we there's a lot of shady stuff that's here. There's a lot of things that should have been followed up on that weren't followed up on. There's a lot of speculation, but the investigation wasn't done correctly. And so, yeah, again, I keep saying it over and over: crap in, crap out.
Yeah.
Okay.
Which equals
bad investigation.
Yeah.
Nobody's going to be held responsible for the death of Mr. Okeefe.
Police Officer John Okeefe from
yet.
the police department deserves better. Karen Nelson, thank you for the super chat. She says, was there anything that could have been proven without doubts? No. Nothing that the Commonwealth put forth is proven without any doubt, is put forward without any doubt, because everything that they put forward is shady. And as Ed said, garbage in, garbage out. And that's what you got. Thank you for becoming a member. Inspire, we appreciate you. Emily, thank you for the super chat. Why didn't they get rid of the dog? Why did they get rid of the dog? And then they ripped up the basement flooring and then they sold the house. Now, this has been talked about out there, but I did not hear during this trial anything about the basement being ripped up. But if in fact that did happen, that's shady shit. And they got rid of the house. That was another thing that made me say, why are you guys selling the house? Oh, well, we were looking in 2021 and we were waiting for the market to become right. We heard it all. It's just a lot of, I don't even have a button for it. It's a lot of bullshit. I just want to.
You never put blood-soaked clothing in plastic bags.
Never.
Even if it's wet. Even if it's wet, it's even worse, right? If it's wet and wet blood and snow all commingled, it's a nightmare scenario for genetic markers to survive this.
Yeah. Thank you, Beckfest, for this comment. This then Bev concerned about defense experts. There was so much fighting back and forth. The judge, siding with the Commonwealth. Melanie Little went to the court and she said that Judge Canton was much better in person than what she portrayed herself on camera. She said that she thought she was fair, and I trust and value Melanie's opinion on this. Schmitty said Ed is back and he's still on fire. Great show. Yeah, well, Ed is back and he's been on fire. Kitty KU, thank you for being a member and a super chat. I think she did it. It's sad that the investigation was so bad. Thank you, DutyRon and Ed and the mods and chat. See, so there's a lot of people out there that think that Karen Reed did, in fact, kill police officer John Okeefe. And there's a lot that think that she didn't. So I respect both sides. And when you get into it's my way or the highway, I don't like that. I don't like to hear it. I don't like people to stop people from having open discussion and conversation about it. But guess what? At the end of the day, our opinions and our thoughts don't mean shit. The jury, with their opinion and their decision is the only thing that matters at this time, because we can jump up and down and we can point out people like this and incompetence and evidence failures and lies and all this other stuff. But at the end of the day, the jury are the ones that are going to make the decision. And when they take this case and they start deliberating, that's the only thing that's going to matter. So everybody fighting back and forth and some of the toxic chats that I've seen, you know, people jumping on people's appearance that are testifying and all this craziness, that it doesn't mean shit. It doesn't matter. It doesn't matter. What's going to matter is tomorrow. And I want to thank everybody for being here. But Ed, I promised to everybody in the chat that you would talk a little bit about the doctor today.
The doctor gave excellent testimony today, and he showed what a true forensic professional is, and he showed how he was able to form a hypothesis, use the scientific method, and then conduct controlled experiments to see if he could replicate the damage to the taillight by either a head, or in the case of a thrown glass, maybe liquor glass or whatever the case was, because it was Mr. Okeefe left the bar with a glass in his hand, and so it seemed like they were able to prove that it could have been a glass thrown at the back of the car that caused that damage, and that the doctor, the pathologist, testified that the injuries were not consistent with blunt force trauma to our victim here, Mr. Okeefe, getting hit by a car, and also the accident reconstructionist said if the victim's hand would have gotten hit and all these things, it would not have been. There wouldn't be enough energy transferred to him because it wasn't being hit in the center of gravity of the body that would have cost him, would have thrown him back the alleged amount of feet that the trooper stated, and done a pirouette and all of this stuff, and none of that was there.
Right. Let's listen to a little bit of him. I want to just highlight the part that he talks about his reconstruction and how proud he was of it. I want to try to find that. I'm not sure where it is in this, but let's just take a listen just shortly, and then we'll wrap it up because we're almost at 2 hours, Ed.
Abilities of each of the team members. You were more focused on the damage to the SUV. Dr. Richler was more focused on the injuries suffered by Mr. Okeefe, correct?
I think that's a fair characterization, although with the caveat that we worked together as a team. So we weren't isolated kind of in those areas, not speaking to each other. We certainly worked together on the analysis.
Understood. Were you provided or did you review certain materials in furtherance of your consultation in this matter?
Yes.
What were you provided?
We were provided photographs of the incident location. We were provided photographs of the Lexus. There were a couple of incident reports that we received. I could look at my report for the full list, but those are the ones.
You can go ahead and do that, Doctor.
Do you have the report with you?
Yes, sir.
I have a copy of it. Based on these data that you were provided, were you able to satisfactorily, to your mind, engage in the consultation that you were hired to do?
Yes.
And come up with some opinions and conclusions based on scientific certainty?
Yes.
Did you review scene photographs of the alleged incident?
Yes, sir.
What information were you able to glean or gather from your review of the photographs, from the scene specifically?
Mm-hmm. So from those photographs, I was able to identify there was fragments of transparent red, clear plastic. There also appeared to be pieces of chrome and black plastic. I also observed what appeared to be glass fragments along with a black drinking straw.
Did you also review some videos?
Yes.
That was out at the scene, maybe a leaf blower?
Correct. It appeared to be daytime, yes.
Okay. What did you note about the photography at the scene of the items that were being photographed?
Well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically, when I go out and do an inspection, especially of a fresh incident, let's say I've got a debris field or I've got tire marks, what I like to do is kind of step into the scene, if you will, where you take global perspective shots and then you step into a specific piece of evidence so that you can, at a later point in time, identify where that evidence is. I noted that in a lot of these photographs, I didn't see a whole lot of that stepping in. It was essentially just zoomed right into where that evidence is, but not really having a great understanding of where was it relative to all of the other evidence.
Or when it got there.
Correct.
Pause it. So that means they didn't do long range, medium range, and close-up photography, which is standard in crime scene investigation. Okay. The long range gives you the overall view. The medium range are your evidence positioning shots, so you know where the evidence is located in the scene. Okay. And then the close-ups, and you do the medium range and the long range, medium range and the close-ups with and without scales and numbers. And none of the basic forensic photography methods were employed here.
Zero.
Based on your review of all the materials that you described for the court, did you get an understanding of what the Commonwealth's theory of the case is, specifically Mr. Okeefe was struck by the Lexus SUV?
Objection.
Sustained.
Did you come to understand that the allegations before the court were that Mr. Okeefe was struck by the vehicle?
Objection.
Sustained. Ask it differently.
Would that replicate what you did in terms of your different question? You were able to replicate the damage to the
I want to get to the part where he says he did that replication. I think it's right here.
Yeah.
Those items in your view.
Well, again, I think this going back to the scene evidence. Again, we knew that there was glass fragments, what appeared to be from a drinking glass,
Here it is.
at the scene of the alleged incident.
Is there any glass consistent with the glass that was supposedly found on the bumper, in the taillight housing, the taillight mechanism, anything from the car, the Lexus, that would account for that glass?
Okay, I think I understand. So the taillight itself is not comprised of any glass. It is all plastic. So that damage, or I should say that glass on the top bumper cover could not have come from the right taillight.
Becky. Good night, Beck.
Now, based on your review of the information that was provided to you, did you undertake any testing of that vehicle? I'm sorry, any testing concerning the damage to the vehicle?
Yes, sir.
All right, can you describe what that testing was?
So we performed, again, this is with Dr. Rentschler and I working together on this again. We performed projectile testing to the tail lamp with a drinking glass as well as a hybrid head form.
Let's take those one at a time. How would you describe the drinking glass test?
Certainly. So again, from our review of the evidence, we knew that we had an isolated portion of damage to Lexus confined to the taillight. So we know that we're dealing with potentially a small object that could have created that. Looking at, again, the evidence in terms of the scene photographs, we know that we have essentially a small...
I'm going to interrupt you right there. You and Dr. Rentschler formed that theory and wanted to test that theory, correct?
Yes.
You were not told that theory by the defense because you've never met us.
Correct.
You were not told that theory by the Commonwealth. You've never met them, correct?
Correct.
Your theory was the product of simply having some facts extant in the data. Got a broken drinking glass, a broken taillight. Let's put them together and figure out if the drinking glass could be responsible for the taillight and vice versa.
Absolutely, yes.
And that was your determination of, well, we were given instructions to reconstruct this. Let's look at every single angle, correct?
Absolutely. And I will note, as part of the engagement with the entity that retained us, we were asked not to do any outside research or investigation of the case. It was to be based solely on the evidence that we were provided.
Okay. As a matter of fact, and importantly, while you were doing your testing, had you ever even heard of the Karen Reed case?
No.
So getting back to that testing, and I interrupted your flow, you were looking at whether or not the glass could have produced the damage to the rear taillight that you saw, correct?
Correct.
And what did you do in furtherance of making a determination about whether or not that was possible?
Certainly. So myself and one of our lab technicians at ARCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight. So it essentially, you can think of it kind of as a giant cannon, but it had a barrel And then there was a valve that would open rapidly, and directly behind that was a pressurized vessel. And depending on the pressure, the PSI of that vessel would determine essentially the speed at which that glass would be projected into the taillight.
So you literally built a cannon?
Yeah, it's pretty awesome.
This guy reminds me of you, Ed. This is just something that you would do.
Yeah, exactly.
And here I stopped it on his dimples because all the ladies are going crazy about this guy's dimples.
You know, just think
pretty smart.
Yeah, but think about why this is so good. Because if you try to reproduce this by hand, you know, you're not going to have the actual accuracy. I mean, if you had a if you were able to regulate the speed of the throw, which is very hard to do, okay, by hand. All right, you know, you'd have to have your chronograph out, and you'd have to take all these practice throws to see if you can reach these speeds, and then you'd have to impact that plastic lens of that rear view light at the right area. You wouldn't be able to do it by hand. So this is the smart way to do it. You create the gun, and it'll give you a consistent trajectory, and you can regulate the speed.
Yeah, I thought it was brilliant when I heard this today, and I was listening to this while I was working. So I had an earbud in. I was running around the warehouse, and I was listening to this, and then I came back in and watched it. And when he told, you know, Alan Jackson what he did, I mean, look, this guy's face lit up, and I'm gonna play it again for those of you. And thanks, Larry, for the super chat. He said Ron and Ed, the good guys, weigh in. We call the balls and strikes, and we're about to wrap it up. But here we go. This is the last of it.
Built a cannon?
Yeah, it's pretty awesome.
Pretty cool job. Tell me what the results of your testing was with this pneumatic cannon that would fire the drinking glass.
Certainly. So we performed 2 different tests in terms of speeds. The target speeds were 30 and 40 miles per hour.
Why was that?
Well, so with consultation with Dr. Rentschler, he indicated that is a reasonable speed at which an adult male or an individual, for that matter, could throw a drinking glass at the taillight.
Had anybody up to that point, told you any specific, let me see if I can rephrase that. Had anybody indicated that there was any evidence whatsoever that John Okeefe had thrown a drinking glass at the taillight?
No.
Was this another example of you and Dr. Rentschler and your team just exploring sort of every possibility and working a little bit in the blind?
Objection. I love that he ended with this, Ed, and let's wrap it up because we got to get to sleep. I got to wake up early, and we're going to have lunch tomorrow, me and Ed. I loved how the defense ended on this because he basically showed the jury that this is an independent guy who has no bias. He didn't know about the case. He wasn't hired by the defense. He wasn't hired by the prosecution. He just was asked to look at the evidence and look at what was there and come to a conclusion. And he did just that. And I think that this was the slam dunk at the end. This was the icing on the cake.
Well, he proved by his experiments that one, the theory about throwing the glass could in fact occurred, and 2, that the theory of him getting hit in the head by that rear light could not have caused the injuries that were sustained, and could not have thrown his body back the distance that the trooper stated. That it didn't work that way. Okay, because you're talking about a grazing hit from the corner of a vehicle, and there's no other damage to the sheet metal around the light. It's just the light, right? There's no transfer, paint chips. There's nothing else there. Okay, so if it was a glancing blow to the hand of the victim, Mr. Okeefe, with the drinking glass in his hand, and you know, he wouldn't then be pirouetted and then thrown back the amount of feet that the trooper said occurred. It just didn't happen that way. In the physics of it doesn't work that way. Okay, I've been involved in several vehicular homicide cases working with accident reconstructionists. But I had physical evidence. I had tire marks on the victims. I had great physical evidence. I had paint transfers, so the Lacard's exchange principle. So we were able to link a vehicle to the suspect, okay, based upon the forensic evidence that were present.
Right.
You don't have that here.
Nothing. Listen, tomorrow, Larry just said that he took the day off from work. So our good friend upstate New York said, hey, I can't wait for this tomorrow. Closing arguments from both sides. And then the jury's going to get the case. So tomorrow's going to be a big day. We're going to be on jury watch, verdict watch with the jury. I'm hoping that tomorrow we get an answer, that the jury comes back with a verdict. I say, and I'm not going to bet my pension on it, but I say that they're going to come back with the not guilty for the top charge, and I'm not sure about all the other charges.
Well, they reduced. They're adding manslaughter now, right? So that's always a sign of desperation. That you're going to you'll go for the lesser charge now because you feel the case is not going your way.
So yeah, Schmitty says, thanks for the Cliff Notes. I thought that this was a good idea. I came up with this at the last second. I was going to just go over the crime scene with you. Melly, thank you for being here. She's a moderator with Vinnie Politan on his private channel, Court TV, Vinnie Politan. Thank you for being here. Appreciate you, Melly. Everybody who's been here and contributed in with super chats, with just comments in the chat, just Larry. We had Miss Burkhart here, Attorney Burkhart from Burkhart Law. She's been covering this case. Melanie has been traveling, and she sent me messages back and forth, lots of different things and questions and so forth. But hey, listen, Ed, thank you for taking out 2 hours and 1 minute of your time here tonight. I want to just say, hopefully justice prevails tomorrow and we get a just verdict here, because as I said, the Commonwealth has not proven beyond a reasonable doubt. And if the jury comes back with a guilty verdict, I will be completely in utter shock. And if that happens, I don't know, man. Ed, what's your thoughts?
We're in this job for justice, right? Justice for the victim, right? And we don't want someone wrongfully convicted. Okay, never want that either. Okay, so I don't think that in its current form and all what the investigation produced thus far should have ever came to trial.
Yeah, this should have never been brought forward. Not murder second degree, and they certainly didn't prove much more than that. They didn't prove anything. As far as I'm concerned, there's reasonable doubt in everything that Adam Lally presented here. Everything. And we saw with OJ, if the glove doesn't fit, you must acquit, right? And we saw the evidence of putting stuff in the trunk of a vehicle and taking it home, and racist comments and all kinds of craziness. This case had a lot of similar things that were screwed up by the police and investigators, and lots of derogatory messaging back and forth from.
Now, here's the problem. Here's the problem with going ahead with this case. If she actually did it, she cannot be retried if she's acquitted at the state level. That's not to say the feds can't take a shot at her. Okay. But more and more judges now are not allowing the feds to do that. And they are ruling against the feds, this being double jeopardy.
Yeah.
But if it's a violation of civil rights, they may be able to bring that kind of case. Okay. But again, if we do our jobs correctly, we get, hopefully, most cases, we get the right answer. Okay. Right. And when you have this kind of craziness, I've never seen an investigation like this. Honestly, I've never seen an investigation like this.
And in 30 some odd years that I've been around law enforcement, worked in 20, you worked over 25, we see so many of these cases, and I've never ever had an experience like this. And this has got my head spinning. like The Exorcist one on steroids. It's just crazy.
I want justice for Mr. Okeefe. I want the right parties held responsible. I want a thorough and proper investigation conducted to get to the right answer. Okay.
Yeah.
And we don't have that here.
Exactly. And a lot of people in the chat saying free Karen Reed, and that's been the hashtag FKR, and free Karen Reed. Listen, like Ed just said, we want justice. And if the Commonwealth, as we know, they didn't prove their case beyond a reasonable doubt, I keep saying it, there's no justice. Police Officer John Okeefe is dead. It was murdered, or we don't know what happened to him because of the way this case was put together. And shame on everybody who's involved. Like where we come from, Ed, if this was a New York City police officer, there would have been a tight investigation. And I'm not just saying that to blow smoke up our asses and for people to say, oh, NYPD. But when there's a case that involves a cop, and forget about even a cop, all of our cases, Ed, I know that you have done an unbelievable job on every case that you've been on. You've taken it full tilt. So on behalf of Crime Time with DutyRon and Ed Wallace, I want to wish everyone a good evening, and let's hope for some results tomorrow. We'll be following this closely. I'll be tweeting, sending messages on X, and I'll be watching it closely. If there's a verdict, we will bring it to you live, and we'll talk to you guys about it after everything calms down. Ed, I know you always got something to say at the end of these things. Let's wrap it up.
Hey, thank you, folks, for staying with us this long, over 2 hours here. I'm going to put my overtime slip in with DutyRon, and I know you could get your true crime fix anywhere you want, and we appreciate you being here and spreading the word about us and building our community to what it is now, over 326,000 subscribers and climbing. Thank you for that. But always be respectful to each other, okay? Courtesy, professionalism, respect to all the members of the community here. And always stay safe, stay prepared, and watch your six.
And thank you, Ed, for that. I want to just send prayers, strength, and positive vibes to the Okeefe family and to all of the folks who are involved in justice. This case was a big fail in my book, but I still have to send prayers and strength to the Okeefe family. And we'll see what happens. We'll see what happens going forward. Thank you all for being here, and stand by for a message from our cop team. But I want to say thank you to the moderators who have kept this chat in line and classy, and you guys in the chat, the live chatters. You guys have been awesome. The replay viewers, we thank you. And make sure you hit the subscribe button, hit the thumbs up, and we'll see you on the next one. Peace and love from Crime Time with DutyRon and Ed Wallace. We thank you for watching. Good night.